So let's start with a story. It was about a young attorney which was working for an American law firm and had a client in the fashion industry. And it was the first time he met with design. And he met a person who was called Nino Cerruti. You can see the person on the left side of the screen. And he said, he told this young lawyer, and the young lawyer was just myself, something which was interesting, a key to the design world. He indicated that creating a new design in the fashion industry is like rediscovering a pattern that was forgotten. And he was just telling that in the fashion industry, there was nothing really new, but it was something that was forgotten and then rediscovered, upgraded, modernized, or tuned. And that was all he said, but it also shows that design has to be contemplated, I would say, in a soft and open way, because you cannot expect things, especially in the fashion industry, totally revolutionary. Then it was my pleasure to, and you can see the picture in the middle. It's a picture of Sharon Stone in a dress in a famous movie, Basic Instinct, when he was examined by a police officer. You all remember that scene. I was involved in it, not as the examiner, but I drafted the contract between Sharon Stone and Nino Cerruti. And in the contract, it was indicated that Nino Cerruti, the fashion designer, Italian fashion designer, would lend to Sharon Stone a dress, actually this dress, for the purpose of the movie. And it was interesting. I didn't see Sharon Stone. I was really disappointed at the time. I think I will still be disappointed if I had to do the contract again now. But that was something which is a good lesson learned. Nobody expected before the release of the movie that it would be such a success. The scene remained in the history of movies, but also the dress. And right after the disclosure of the movie, or after the premiere, Nino Cerruti received hundreds and hundreds of requests for purchasing the famous dress, the white dress. Unfortunately, he didn't foresaw to protect or even to produce the dress, because it was not, he didn't expect that it would be a dress for sale. And it was a big mistake he made, because it would have been a very successful dress. And if he didn't contemplate the design as such, because he didn't think, as he was explaining to me, that it would be something really fashionable. But then I received a little something from him. It was a bottle like this one, and I was asked to check. It was the alpha version of the perfume that you can see on the right side of my screen. And perfume cannot be protected as designed, but the shape of the bottle could be protected as a design. And it's, if I'm talking to you about this, it's because you do not really decide what happens to your IPR when you are protected or not protected. And if somebody is suing you, and that's the purpose of it, enforcement, meaning being sued in one way or another, you don't know what you can do. And one day I received a claim against my perfume or the perfume of my clients on the basis of this. And as you can see, basically there is nothing which makes the two perfumes or the two designs alike. But nonetheless, the Paloma Picasso or the industry behind just decided to sue Cerruti because they considered that the two perfumes were alike and we were actually infringing their design. To be honest, the case didn't go that far, but because we just tell in a not very nice way, really the lawyer types of answer that they can go to hell because there was absolutely nothing similar between the two. But nonetheless, based upon the design of the Minotaur perfume, they decided to go after us. And that you cannot control. But this is something you have to live with when you are a lawyer, and that was a design issue after all. So one thing leading to another, and so also something that is very interesting. I was walking down the street of my village, a little village in Alicante, and I was going for an ice cream, nothing really extraordinary, but when I went close to the shop, I saw one young guy wearing a jacket, a Ferrari jacket, and trying to seduce two girls. And when I saw the guy, I was looking at the jacket, and it didn't look like a very good quality Ferrari jacket. But across, behind the guy, the person, the young guy, I saw this. And you can see here, that's where we have the ice cream shop. And that's what I saw. And something puzzled me right away because it looks like a Ferrari. And the guy was wearing a Ferrari jacket, but he was not really the type of a guy, I'm sorry for that, just watching at the jacket, to purchase a car over several hundred thousands of dollars or euros. So I get close to the car and I started to take pictures of the car. And it looked like a Ferrari. And when the guy was seeing that I was taking picture of the Ferrari, he came very happy, give me a big smile. We are in Spain, everybody's nice and kind. And he took the car and decided to show off and put the engine and left straight away. And you can see, and the car was making kind of a sound of a sport car, but didn't have the hundreds of horsepower of a real Ferrari. So I got puzzled and I took the picture of the car plate and I sent the car plate to friends in the police in Spain, and I said, can you identify what car is behind the car plate and who is the owner of the car plate? And they did it as a favor. And they come back to me straight away and they told me, if you want us to give you the owner of a car or the brand of a car, just give us a proper car plate. And then it was the beginning of a saga because the car plate was a fake. But the car was also a fake. It was not a real Ferrari. And it led to an investigation led by the National Police of Spain. And that's what happened. It was called Operation Cavallino. And that's what they found in the neighborhood of Alicante, a garage with a lot of Ferraris. But it was not an official Ferrari dealer. And so how can it be a fake Ferrari? And Ferrari is very famous not only for the brand, but also for the design of the cars. It's very easy. You take a second car, damaged car, or second-hand car, like this one, and then you just tune it. How do you tune it? You use plastic or whatever, and then that's what you do. You change it. You just reshape a Toyota car, a Celica car, into something totally different. And you may wonder how you can be sure to make a proper Ferrari. You just go to the European Union Property Office database, and you just look for design. And then you take the design of the Ferrari, which was protected, that's Ferrari Modena. And from there, you just make sure to confirm the design. And that's how you have a Ferrari. Everything is fake. It's all built up. Everything also for the central engine. You don't have a central engine. You still keep with your original Toyota engine, but you create a mold and you place it in the center of your car. And from the outside, it looks a very nice Ferrari car. And that's what they found. Mold and everything, stickers to make the Celica look like a Ferrari car. The only thing that was original, because it was too complicated, too expensive to create, was the wheel hub in the center. Really, this part was the only genuine part of the Ferrari, of the car. So you may wonder, because that's all something I will come back to that, what was the right holder was doing, the Ferrari was doing, because all of a sudden he was receiving requests for purchase of a lot of wheel hubs from a person who was not an official Ferrari dealer. He should have raised the bell, because that was something was going definitely wrong with that. But apparently they were not really concerned about it. They didn't really pay attention to that until the moment the National Police of Spain went to them and said, didn't you find anything strange in the way a garage from nowhere was purchasing wheel hubs, and a lot of them, or I mean a lot of 4 per car, but they were making quite a few cars. So that's something that is interesting, because that's really a point which I will mention again about enforcement of design, but also for enforcement of other IP rights. You must get the right holder behind you and supporting your lawsuit. So that was to give you tips of different things which you can find and being faked or copied with respect to designs. So making it more, I would say, legal now. I mean, TRIPS covers minimum condition of protections of intellectual property right at civil, custom, and criminal levels. We all know that. And that will give us a natural roadmap for the suite of the presentation. We will talk about civil, custom, and criminal lawsuits involving design. And the key point that was mentioned by the Jessica many times, and rightfully, the design must be validly protected in the country in which the right holder wants to initiate legal action and claim for a prejudice. And we will see that there is I would say, a weakness somewhere in the European system, because we are not checking the novelty, the individual characters, or even the technical function of the design when we grant a design at the level of the EUIPO, for instance, for community design. And that may lead to some consequences in terms of, I would say, efficiency of a design case before European courts, because there can be some claims or counterclaims that could put the case being less effective in terms of time. So also I want to mention that in the European Union, we do not have international exhaustion of design rights, which are coming from outside of the European Union. So importing a design or product with a protected design, even if it's a genuine one, when it enters into the European Union, it becomes a counterfeit by definition, because we do not exhaust internationally IP rights in Europe. So that you have some examples. The first one, it's a case which I had to deal with a long time ago, and it was a wheel blocker for cars. And actually, it didn't go any further because of the technical functions of the design, because the design was also was more of a patent than a proper design. The one in the middle, it's a case. It's about little houses like that. And it's also a case which is mixing design, I would say, and also copyrights. More interesting is the bracelets, which are like these ones. And it's a case which was dealt with by the French custom. And the French custom received the tip that there was a truck full of these. And the person who pretended, and I meant pretended, to be the design owner said that he had design protections over this kind of bracelets. And the customs went and seized the truck. And you can imagine how many of these you can put in a truck. It was crazy. It took for the custom a full brigade of custom officers 2 weeks to identify and to mark each of the seized products. And after 2 weeks, when all the paperwork was done, the owner or the person who claimed to be the owner of the design came and says, sorry, we made a mistake, we didn't register the designs. And they decided just to waive the case. But at the end of the day, it was 2 weeks work for the customs for nothing. And when I say the custom, it was not just one person, it was 6 persons to do the proper work for absolutely nothing. And that is really a message that person working in the field should pass on to right holders. I mean, it's not a normal proceedings. I mean, when you are doing IPR, you really need to have the right holder backing you up, whether it's a design, I would say even more for a design than for other IP rights, such as trademarks. So I had some opinions, and I decided to ask before presenting and making that presentation, a couple of friends, which are part of my network, and I asked 2 judges from Supreme Courts, 2 judges president of Courts of Appeal, specialized in IP, 1 president of IP court, and 2 judges from commercial courts in specialized sections to make sure that what I will tell you was correct. And I also called 2 police officers to make sure that what I was saying to you was what they were experiencing in Europe. So basically, that's a classic design litigation. You have a claim, which is a litigation, and then you go to national courts, and then you will ask for damages or prohibition to use the design or to seize the design. But what you will do automatically, and that's what they do in most of the cases, you will find a counterclaim in invalidity, because you must know that the design may be valid, but you know now that a design in Europe is not examined as such in terms of substantial conditions for validity. And then you go for a counterclaim in invalidity. And then that's the first hiccup, because challenging the validity of a design could be done by the national courts, but they do not always do that. They may do that, but not all of them. And there is a possibility to create what we call a torpedo. The torpedo will be for the national court, upon request of one of the persons, of the parties, not to deal directly with the question of validity of the design, but to refer the case to the EUIPO and ask for the invalidity division to take a decision, which can be then appealed to the boards of appeal, which can be appealed to the General Court of the European Union, and then to the second instance of the Court of Justice of the European Union. And that takes time, and that takes years. And that's really an issue, because remember what I mentioned originally, time is of the essence of an efficient case. And that's for me the main, the main weakness of the design system the way it is, because what I would do, unfortunately or surprisingly, not everyone is doing it, would be to systematically claim for the invalidity of the design, which is used against you before a national court. And that is really the weakness of the system, according to my opinion, and also according to the opinions of the friends which I contacted. But that could be changed. Why not? On the other side, as mentioned yesterday, you can get a design in 24 hours or 48 hours in the office. This has to be balanced. So knowing that, you can go for civil remedies in Europe, and what you can ask is damages or seizure of the counterfeiting goods, but provided that the design is valid. At the criminal level, referring to TRIPS, only willful infringement of trademarks and copyrights can be pursued criminally, or that's a minimum requirement which is put for criminal IPR infringement by the TRIPS agreement. And as I say, you can have fines and or imprisonment. So the question is, what do we have in Europe for the 27th of the European Union in terms of criminal infringement of design? Actually, every member state of the European Union has a criminal possibility to go against design infringement. But the question is not so much if we have something in the legislative arsenal, but whether if we are using it. And the response is no. In reality, there is no use of criminal proceedings in case of design infringement. There are no cases. First, they don't have that many cases in Europe, even at civil level, of cases involving design. But at criminal level, there are very, very few. There is actually one for the Ferrari case, which I mentioned, and there is another one which is currently dealt with, and the case is a suit. The pleadings are taking place now, really nowadays, and will last until the 11th of December. It's in Paris, and it's for Hermes handbags, which are sued criminally. So, criminally speaking, we don't have much, but the weakness is also because the right holders are not really involved and supportive of IPR cases, and definitely for design cases, as I mentioned originally, for the Ferrari case, I talked yesterday to the person in charge with the Spanish police. They said that Ferrari was not really pushing behind. This is not what is currently going on in Paris with the Hermes case, because Hermes just decided to support the criminal investigation using the best IPR lawyers they were having in France, and it's currently before a special court. So just go criminally if you you have a strong case. And design, we saw the weakness. If we start to discuss the validity of the design, it's not very good. So very often, and that's what happens in the cases which I was referred to by my judge's friend, they are always, or if not very often, mixing design and other rights, in particular trademarks or copyright. And in Europe, it's possible for design to be also protected by copyright. It's called the theory of unity of art, and it's been accepted twice by the European Supreme Court in two cases, Floss and G-Star Row. So you can use it, and trademarks is very often used, but the weakness, possible weakness of design, because it's not really investigated when given the registration right, is probably explains why design is not used that often. And you can use design, but you have other things, and that's clearly what's going on in France for the time being. They are using money laundering, they are using tax fraud, they are using other stuff. I'm talking, of course, of the Hermes case. And the Hermes case is a case where, for the time being, $12 million or euros have been seized, and they expect to be confiscated at the end of the judgment. So we are not talking about low, limited level of money. We are talking about huge amount of money, because 12 million euros, it's a lot of money just for bags, ladies' bags. But that's what it is. And this is why the case, which the Hermes case, is not before a IPR section, but before a financial fraud section of the Criminal Court of Paris. So we also have another possibility. That's the last one, and I'm getting close to the end of my presentation. It's you have civil criminal actions, but you also have custom actions, and custom are very efficient in seizing IPR design infringing products. And we have a regulation. It's a legislation just for that, and it covers among other intellectual property rights design. But again, design are not really used or not used that often because it's easier to identify a trademark product than a design. But it exists and it's in the legal arsenal of enforcement of design. I'm passing that, and this is it for me. That's a presentation of enforcement in design in Europe. You have civil, criminal, and custom possibilities, but in all cases, you must be, if you are the right holder or if you are counseling a right holder, you should make sure that is really supporting the case. Thank you very much.